Yeah. Okay. She's admitted to practice in all states courts in California, in the United States District Court for the Central and Southern Districts of California, and in the Ninth Circuit Court of Appeals. She was also an extern in the chambers of the Honorable Andrew J. Weistrich of the United States Federal Court for the Central District of California. And she's going to come today and talk to us about employment law and protecting pregnancy rights during employment. And I'm going to make sure that you have the ability to share your screen.
I see that. All right, if you're ready for me, I will do that now. If that's okay.
Yes, go ahead.
Excellent. Okay. All right, can you see that okay?
Yes.
Okay, perfect. All right, well, first of all, let me thank Akila and the National Black Doulas Association. I'm so excited to be here and to present. A little bit about me, you heard my intro, which I won't repeat, but I do represent workers that either are pregnant or have been pregnant or thinking about getting pregnant, and often with relation to how they are beginning to experience some changes in their workplace. Usually they come to see me when things have kind of already gone real sideways. I try to counsel them through that situation. Sometimes we do end up in litigation, which is fine. That's a big part of what I do, but I thought I would reach out ahead of time to maybe some healthcare providers and doulas who can maybe see these things kind of coming down the pike and at least have the tools ready to advise. Do you refer to your, is it clients? Do you say doula clients? Okay. So refer to your clients like, you know, this sounds like it might be a situation where you might want to consult an attorney, or it might be a situation that sounds like at the very least it's not good, and maybe give you some tools that you can use to help them along in kind of their total well-being in relation to not just having the baby and having, you know, a good experience for them and becoming parents or, you know, delivering the baby, but then also in relation to their workplace. So first, and before we start, like if you want to throw out a question, like, don't be afraid. I don't like waiting for the end for questions, just because I feel like a lot of the time, if you have a question, somebody else has the same question. And I would like this to be a free flowing discussion. So feel free to just stop me at any time. Also, I'm assuming, Akila, can they put questions in the chat? I don't see the chat on mine while I'm screen sharing. I'm not sure how that works, but if there is a question, I would actually prefer you just to voice that.
Okay, yeah, there is a chat. So if you guys, you can go ahead and feel free to unmute yourself if you want to ask a question.
Perfect. And I do tend to talk really fast, so I will try to slow down a bit, but I know that about myself, so I'm just warning you, if there's something I said and you missed it, go ahead and ask me to repeat it. I don't stand on any sort of formality, because I feel like ultimately the goal is to help our clients, and the only way to do that is a free communication. So first of all, what is workplace discrimination? Legally, discrimination is what occurs when there's an adverse action in the employment, and that adverse action is due to a protected status. And so I've listed a couple of examples. One is somebody being paid less than somebody else performing the same work simply because of their sex, right? Because they're female. Or somebody who works at a place with somebody else, and the person who is single got the promotion and the person who's married did not. And maybe the assumption was, oh, well, if they're married, you know, they have somebody else at home who also works, they don't need this money, or, you know, they're not going to work that hard because they're married, or something like that. That has happened. Or another one is where somebody gets a promotion over a pregnant person. They say, oh, well, they don't, you know, they're assuming the pregnant person is not returning to work, right? They say, oh, well, you're not going to be here. You're not going to come back after your baby, or most people don't come back after they have their baby. And so we didn't really consider you seriously, even though you may have been equally or possibly more qualified for the position. So these are all examples of basically an actual tangible, like loss of money, loss of title, or deprivation of ability and opportunities that occur in the workplace. And this can happen, especially related to pregnancy, I would say, in kind of three main areas. One is pre-pregnancy. So you see this come up when it often happens right after somebody gets married. And I'll just disclose, this actually happened to me when I got married and I worked at a law firm. So I got married, and then almost, I would say right after the honeymoon, the question started, okay, how old are you? What are you guys thinking about kids? Do you want kids? And, you know, when I had kids, X, Y, and Z, and you're kind of like, can we like serve this complaint? Or are we talking about the kids I don't actually even have yet? Like, it was a very strange place to be in when all of a sudden people at work were making assumptions about your family planning plans or what somebody's pregnancy plans may be. And it's actually, at least in my state, California, not legal to ask people about when are they trying to have kids, or, you know, don't wait too late and all these kinds of things, because it can create an environment of hostility. And we'll get to that in a little bit, of hostile work environment. But it occurs when there's, so pre-pregnancy, those types of questions, and also maybe questions about, you know, you probably shouldn't have kids, right? Like, you're not the right type of person to have kids. I've seen that as well. Mainly it does come up during pregnancy, though. When a person is pregnant, sometimes they request accommodations. Sometimes they look visibly pregnant, and they get comments like, are you pregnant? And that person actually may not even be pregnant. Sometimes they are, sometimes they're not, which is very awkward. But a lot of times, if you have a medical condition related to pregnancy, and so I've listed out preeclampsia, gestational diabetes, or even having a miscarriage. These are special medical conditions that require certain accommodations. And depending on the state you're in, the employer either has an obligation to provide it or it doesn't, right? And then post-pregnancy. So this is issues related to lactation. This is issues related to postpartum depression. It can be issues related to taking family leave time, and we'll jump to that a little bit more later. But there's often, especially post-pregnancy, for instance, when somebody says, okay, I'm ready to return to work, and they say, oh, well, we actually don't even have that position anymore. While you were gone, we eliminated that position. We have this other position, which is, you know, not program manager, what you're doing, but maybe as a desk assistant, or maybe it's receptionist, something that's, it's not at high of a rate and it doesn't pay as well. So that happens a lot. The cases, at least that I've seen, are not developed yet in terms of treating infertility. Is that something that's related to pregnancy? Or I would say having an abortion, is that something that's specifically related to pregnancy? Those cases I've not seen yet, and it's not in the legislation that I've seen yet. There have been attempts, at least in California, I believe, to include fertility or being infertile as a protected status. I think infertility falls under disability, but specifically as relates to pregnancy, that hasn't happened yet. So just a little bit about the actions that the EEOC has pursued. So by way of background, the EEOC is the Equal Employment Opportunity Commission. It's a federal agency that is tasked with enforcing and prosecuting the federal anti-discrimination laws, and that includes pregnancy discrimination laws. And from time to time, usually they don't take on their own cases, but sometimes they do, especially when it's a kind of a wide-ranging, you can imagine a class action against a company that maybe disenfranchises all of its pregnant workers, something like that. And so this is a list of the types of actions they have prosecuted, I believe, since 2011. I'm not sure within the last 4 years if they've particularly been focused on prosecuting, employment discrimination issues, but I would assume with the new administration, this might come back to the forefront of something that they do. But, this is some kind of textbook type issue. So refusing to hire pregnant workers, firing pregnant workers once they disclose that they're pregnant, discharging workers who maybe need medical leave for pregnancy-related conditions, placing pregnant people on involuntary leave. That's something that you see a lot of, where the employer doesn't really want to make the accommodation and say, instead of us actually trying to figure out how to work with you, we're just going to say, you go ahead and you take your FMLA now. You go on leave now. It's actually illegal to do that if they can be accommodated in another way. Requiring doctor's notes from pregnant workers that they don't require from other workers. So assuming you have, let's say, a wide workforce, and maybe you have a policy regarding workers with disabilities. If you don't require a doctor's note from them, but you do require a doctor's note from pregnant workers, that in and of itself is a violation. And similar to that, it's a failure to accommodate pregnancy restrictions, where you might accommodate a ability restriction, but not a pregnancy restriction. So these are just some examples of the types of actions that they prosecute. And I want people to notice that obviously the worst thing, probably the most severe adverse employment action that can occur in your workplace is a termination. Usually by the time people have come to me, they were terminated. But it doesn't always have to include termination. In a lot of these actions that I'm listing that the EEOC prosecuted, the people were still working there. The people weren't actually terminated. They were just maybe minimized in their position or had experienced this particular kind of these discriminatory actions, but actually we're still working there. So I just want to make clear that sometimes by the time you come to an attorney, you may have had the termination happen, but it's not necessarily the case, and it's certainly not required if you're going to consult someone or go to the EEOC or whatever, the state agency. Just by kind of inquiry, where is everybody based? I know some people were from Texas. There were some Maryland folks.
Atlanta.
Okay, Georgia.
Chicago.
Awesome. I was born
Florida.
there. Cook County, Florida. Okay. Yeah.
Florida.
And so, say again?
Houston, Texas.
Okay, Texas.
In Florida.
Wonderful. Okay, great. So because everybody's in a different state, I mean, the EEOC is federal and it's going to enforce all the overarching laws that apply federally, but there are different regulatory agencies, administrative agencies in each state that manage their own anti-discrimination laws to the extent that they exist in relation to pregnant workers. So I talked a little bit before about discrimination, how it requires basically an adverse employment action against the worker. Harassment is different, and harassment can be discrimination, but all discrimination is not harassment, if that makes sense. So I put an example up here, and I actually adapted this from a different case where the supervisor was saying basically only dark-skinned people were only fit for working in the back office. And then the manager agreed and only put light-skinned people in the front and put all the dark-skinned people in the back. But it's applicable across the board. If there's somebody that says only this type of group of people should work in the front and these other people should work in the back, just the statement itself is a harassing statement, but the actual placing of the people, the actual management decision to move those people and act on the statements is what's the discrimination, because ultimately the people that are generally in the front, they get seen by more customers. If it's a restaurant, they might get more tips, or front of house type situations, and the people in the back in the kitchen don't get the tips. They have to kind of rely on the generosity of the people in the front of house. It actually has tangible consequences, both in the pocket and in chances for opportunity advancement in that establishment. So I just want you to understand how they're related. The harassment standard is a little bit different than a discrimination standard. It's both subjective and objective. What that means is not only does the person who is being harassed have to find it objectionable and say, I don't like being called XYZ, right? I don't like you saying I'm knocked up, right? It also has to be objectively problematic for other people. So a reasonable person would also have to say, yeah, I think that's a terrible statement, right? Sometimes it happens in the workplace where it's called horseplay a lot. And so they will say, oh, well, they all kind of joked like this, right? Everybody was kind of making these comments and cracking on your mama or whatever it is. And that can be the case, but at any point, it's almost like a consent, right? Maybe it's okay to make jokes, but if somebody once they start to express that they are uncomfortable with the joke, and a person in a objective position, maybe who doesn't work there, would say, yeah, you know, that's an objectionable joke. I find that to be unreasonable or distasteful, offensive. That's kind of the line for harassment. There's another type of harassment, which we've heard a lot in the past year or two, called quid pro quo. And that's a little more specific. I don't usually ever see that in relation to pregnancy. That's almost exclusively a sexual harassment thing. Quid pro quo is, if you go on a date with me, I'm going to put you on the good shift, right? If you don't go in the back room with me, I'm going to cut your overtime. So that's actual trading sexual favors, basically, for benefits in the workplace. And that, I don't ever really see that come up with pregnancy. The closest I've seen is where somebody who was just a gross sexual harasser in the first place then started harassing the pregnant person, saying like, I'm into pregnant people. Yeah. Like, are you interested in going out? These people, I know these people are out there, and they're in the variety of workplaces. They are around. So just be aware. So this is a little bit just of some of the examples of the type of harassment that could occur. Harassment, at least under the federal laws, can include verbal harassment. And so I was talking about slurs. I use that phrase, knocked up. Some people might be okay with that phrase. Some people clearly are not. Jokes, comments. This one I see a lot. You gained too much weight, or you haven't gained enough, right? And there's a variety of this, like, are you carrying twins? Have you checked? Are you sure? Yes, I've checked. I have a doctor, right? This one right here, I knew you were pregnant because your boobs were bigger. That was actually said to me. That wasn't even Kate. That was just, yeah, that was interesting. And the person really to me, I felt like they weren't trying to be offensive. It was an offensive comment, but in their mind, they were just like, oh, this is just stating facts. Like, I really believed this because this is my observation. Not an appropriate work comment for sure, but this is what they thought. And so a lot of people don't understand that these comments can be harassing comments, right? They think they're just talking. And we'll talk a little bit about maybe strategies to deal with some of these types of comments. Obviously, unwanted touching, especially when you're pregnant, happens all the time. They want to touch the belly. And nonverbal harassment, like a lot of staring or pointing at people or walking around, you know, with a pillow in your stomach, and I'm Susan, I'm pregnant too, right? Haha, like that's not great. So this is just a little bit about what hostile work environment looked like. And again, people don't necessarily, the intention of the person who is doing the harassment is not really at issue. It's more, what was the comment? Was it bothersome to the person it was made to? Was it objectively bothersome? Is it objectively an offensive comment, right? Is it work related or not? I mean, I can't imagine any of these particularly being work related or necessary to performing the person's job. So that's just a little snippet of hostile work environment. I'm sure you guys have examples, working with pregnant people way more than me, of things that you've probably heard from your clients about things that they go through at work.
I have a question.
Yes.
What was your response when they made that statement?
When the person made the statement to me, I just looked at him and I was like,
oh, it was a guy. Wow. Okay.
Oh yeah, it was I knew you were pregnant because your boobs are bigger. Yeah.
Yeah.
I said, why are you looking at my breasts? And then he was like, I look at everybody's breasts. And I was like, and so, I mean, like I said, I don't think he was probably trying to be provocative, but not rude, if that makes sense. So I just said, okay, you can go. And I just like gestured him out of my office, and I went and I closed the door. And that was it, because honestly, he was an attorney as well. So like if anybody knew, like he knew.
He knew better, yeah.
He knew better, but I don't, like, in his mind, I don't think he thought, oh, I'm harassing her. I think he was like, oh, I'm just talking to somebody about, you know what I mean? Like, I don't think people necessarily think this is offensive. But maybe they should start, because that was really not a comment that anybody needed to make at all. And the funny thing is, like, he was right. Like, they actually were, but that's not the point. The point is that's not a comment you make at work, right? It's not appropriate, especially he was a senior attorney to me. So, I mean, there's kind of that subordinate relationship. So it was uncomfortable at all. I did what I felt like I could at the time, which was just ask the question. And then he responded, I look at everybody's boobs, in which case I was like, okay, and you need to leave. So, and that
Right,
was it.
goodbye.
Right. It's tough. Because a lot of times people do know better, but sometimes they really don't. They just don't. So some of the things that can occur when people are being discriminated against or harassed in their employment. I mean, obviously, if you're not getting a promotion or not getting a bonus because you had taken your FMLA or whatever, like, you're going to have some economic losses, right? You're not going to get that money that you otherwise would have been entitled to. You may not be up for a promotion. You may not be eligible to operate in any sort of commissions that could have been earned, that type of thing. And it's pretty straightforward. One of the things I wanted to put in here and talk about a little bit was economic, also in terms of medical insurance, right? Like, we're still in a system where your medical insurance primarily is provided by your employer. If you are ultimately terminated because of pregnancy discrimination, you have to figure out, one, do I have a way to continue my medical insurance? Am I even eligible for COBRA? And if so, how am I going to pay for it? Right? Like, this is a whole different level of additional results besides just being terminated from work and the loss of that income. On top of that, I would say the physical stress of maybe not being able to see the physician that you previously had under your medical insurance, because now if you've had to change insurance or maybe you can't afford the COBRA, you might not be having continuity of care, at least on the healthcare provider situation. Physically, once you have the baby, there might be less milk production than you normally would have, because now you don't have a protected leave. If you were termed during the pregnancy, you're trying to figure out, one, can I get back to work usually? And due to the stress of it, I mean, just the physical stress of, I think, going through bearing the baby and trying to recover from that without knowing that you have a job to go back to is very stressful. And that cycle, I mean, you guys know that cycle of the milk production, the stress, it kind of feeds into itself and ultimately can create other issues. And then the mental stress, right? The mental, I think, damage of losing your job, either while you're pregnant or just thereafter. You don't have a protected leave usually. And so instead of spending that time at home at peace, bonding with your child, you don't have that. You're trying to figure out, do I get another job? How do I get another job right now? I have a tiny infant. I may or may not have childcare. The childcare I was going to have required me to have an income coming in, but now that I don't have an income coming in, how do I make this work? Right. These are all kind of issues that people are dealing with when they have been terminated because they've been pregnant. On top of that, there is, I would say, all the other attendant issues like loss of self-esteem. And I see this at least come up in my practice when people have come to me, and often they bring their babies into the office with me because they don't have childcare, right? And so they're like, I used to be a project manager. I used to be the #1 salesperson at this company. And now, they just cut me loose. I don't have any, like, they didn't see value in me as a person professionally. That's a hard thing to accept, that basically the company was willing to let you go because you had a child, right? Like, that is a blow to many people's, I think, professional working self-esteem, the way that they felt about their job, because we spend most of our time at work, right? A 40-hour week is becoming a thing that is going away. People are spending more and more time, especially during this COVID, people are spending more and more time doing stuff work related. Probably only spend more consistently time sleeping than working. And it's a very big blow to people's, I think, professional identity when they lose their job, especially behind, not even something that they did, but behind being pregnant. So this can also come up when people are feeling maybe a little resentful, right? And not purposefully, for sure, but they feel like, well, now I'm just someone's mom, right? Now I just sit at home and And there are some people that's their dream. Like they want to be at home with their kids, and that's great. But it's a much different thing to choose that for yourself than when you've been terminated from your job. And that's kind of, it's been foisted upon you, if that makes sense. Any questions so far? No? Yeah, Rain the doula.
So my question, a lot of the scenarios that you brought up and you're like, oh, I haven't personally seen this a lot with pregnant women, like transitioning from working as a dancer in the club to a birth worker. I do have a lot of clients in the industry still, or, you know, people who are considered independent contractors, people who are, you know, tattoo artists, dancers, things like that. Are they still protected? Because a lot of us don't feel like any of this pertains to us, because we feel like, oh, we just have to take what we take, you know? So like, I would like to be able to share this information with my clients and let them know, like, oh no, you still, I try to tell girls, like, you're still a employer, you're still, or, you know, birthing women, that you're still, you know, you go to work and you make money and it's legal and it's taxable, you're still protected. So
Yeah.
a lot of people feel like, you know, oh, they said this to me, I got to take it. Or, you know, like, for example, with my oldest daughter, when I first started dancing, I was pregnant, but, you know, I didn't show for a long, long time. And I told someone when I was promoting that, hey, you know, like, I'm not drinking, you know, I'm pregnant, but I haven't told anyone. And it's Super Bowl weekend, and it gets to the manager that I'm pregnant, because, you know, girls hate in the workplace. And they told, even though I didn't look like I was pregnant, even though, you know, and he told me that if I wanted to continue working, I had to pay an extra $100. It was Super Bowl weekend. And he was like, oh, if you want to work tonight, then if you're pregnant. And I was like, well, I don't look pregnant. He was like, well, clearly you don't look like pregnant. You're what, like maybe a few weeks. I was like 4 months, but I didn't look it, because I still, so he basically, you know, extorted me. It was like, if you want to be here tonight, you have to pay $100. And I paid it. But, you know, looking back, I still felt like that's not fair, because things like that happened in those type of industries all the time, or, you know.
Yeah, it's, I'm sorry that happened. Yeah, it's so tough, because I feel like a lot of the ways that the laws are written are specifically for employees. And I mean, I see this in California. We've had a lot of, I don't know if you guys are familiar with, we just had a big no on 22 related to like the Uber drivers and Lyft drivers, and like basically whether you're an independent contractor or an employee. And a lot of companies use the independent contractor language to get out of paying employee benefits. They don't pay payroll taxes, they don't deduct disability, they don't deduct employment taxes, and they don't have to pay workers' compensation. They pass all of that on to the worker, who is the independent contractor. We had a law that was passed that said, okay, you can still have an independent contractor, but they actually have to be able to work for other people in whatever the industry is that you have, right? They need to have like a written contract. They need to have a separate business address. Basically, they need to be a business. If you're really going to say that they're independent contractors, then truly they need to be independent contractors. And a lot of people have balked, a lot of companies have fought this, because they don't, basically they want their cake and to eat it too, right? They don't want to be employers, because they don't want to have to comply with these laws and the labor laws that would normally apply to employees and employers, but they want the benefit of the labor, right? And they want it as cheaply as possible. So whether you make anything that day, right, is up to you, right? They don't have to pay you any sort of minimum wage for being there. In fact, like you said, they can charge you for the benefit of being there, which is abhorrent and terrible that happened. So it is very hard. I have seen, so at least in California, and that's where I'm based, so I'm way more familiar with the laws before we get to them. I have seen language in some of the laws that says not only is the company responsible for protecting employees from discrimination, but also they are responsible for third-party discrimination. So let's say if the FedEx guy, I have no beef with FedEx, but let's say a delivery person, whoever, is frequently coming to the office and making comments to the receptionist about whatever, X, Y, and Z. If the receptionist person complains, they have an obligation to talk to the FedEx guy and say, hey, don't do that. Because they have an obligation to maintain a health and safety environment that doesn't discriminate against their people. So even if the person doesn't work there, that obligation still applies to contractors. There is a question about whether it goes the other way, right? Whether if you are an independent contractor, if the employer has an obligation to keep the independent contractor in an environment free and safe from harassment and discrimination. I mean, I would argue that it does. But in California, we've written the laws to include basically contractor, employee, worker, or person performing services pursuant to a contract. But every state is, I mean, I think that we live in probably the most employee-friendly state. And I don't know that those laws apply. I don't think they apply, at least federally. Title VII, I don't think it has that same language. And so, right, if you're an independent tattoo artist, if you're a hairdresser renting a booth, if you're a dancer, I don't know what protections you would have under this type of scheme. But it doesn't mean that you can't employ some of these same techniques that we're going to talk about. It just means you might not have legal recourse under the laws I'm going to talk about. Does that make sense? Okay.
Most likely it's like if you're in California and that's how the literature is set up in California, then in Texas we are even less likely to have whatever y'all have set up, because you know dancers have unions and everything set up in California, and out here sadly it's just like get what you can, like, and not just dancers, but even, you know, like you stated, a lot of people who pay to work, who pay booth rent, tattoo artists, hairstylists, you're just kind of on your own. But employers do take advantage because, you know, you pay to work, but they also want to tell you, oh, but don't work nowhere else, or don't go nowhere else, or don't promote any other establishments, but we're not going to back you. So it is kind of like but I'm definitely going to continue to stay tuned and see what I can use to that we can implement for, you know, my clients and myself and other people in that type of industry. So
good. And it may be that things are changing legislatively, but you know, the law is kind of always catching up to what reality is. So even though I would say laws are going in a good trend in some ways, like they're always going to be behind what people are actually doing. That's why I was talking about that No on 22 legislation for Uber and Lyft or whatever, DoorDash. You know, people have been doing Uber and Lyft and DoorDash for 8 years now, and they just had this thing on the ballot to this year. So it's taking a while for things to catch up, but we'll come to Texas law in a bit. And you're right, like it's clearly not as protective, but there's still going to be some strategies that you can hopefully use for your clients and things to move forward. So talking about just the economic damages from discrimination. So we talked about medical insurance. We talked about possibly people not getting put up for new positions. And here are the stats. And this is just this year. Between August and September, 1.1 million workers age 20 and over dropped out of the labor force, and 865,000 of them were women, right? Yeah. And this is based on the fact that, you know, women are still the caregivers in the house. Women are still the people who are kind of managing kids at school and picking up basically all the unpaid labor that happens in the home. It's generally falling on the women. So this is kind of, it's related to pregnancy because also they're more likely to be the right, they're having the children and they're rearing the children. And so it's just a problem in terms of, this is a kind of a function of the way that our economy is built, because this is not labor that we pay for. This is not labor that we value. And the government doesn't subsidize it in any way. They could easily, well, let me not get into what the government could or couldn't do. Let me just talk about what is. And so we talked a little bit about the kind of the damages that occur when people are having discrimination happen to them. And sometimes, like we talked about a little bit of this, and I don't want to dwell on this again, but sometimes the babies have lower birth weights. And so I wasn't able to find the study, but I know that I had read it in one of the JAMA journals, basically saying where the mom had been terminated from employment. And they did a study where the mom had been terminated from employment during pregnancy, and the mom that hadn't during pregnancy able to went back. On average, those babies had a higher birth weight, the ones that were not terminated. Right. And so there's a question of whether there was correlation or causation related to, what caused the lower birth weight, but they were just saying they couldn't say it was causation, but there was a correlation. And so that's just something to be mindful about, that ultimately it does have repercussions for not just the parent, but also the child. So turning to kind of federal pregnancy protections, like what exists, right? In terms of the employee context, there is Title VII, which is basically the Civil Rights Act of 1964, which includes the Pregnancy Discrimination Act of 1978. If the employer has 15 or more employees, then they are subject to this law, which says you can't discriminate on the basis of sex or pregnancy. It's pretty straightforward. The burden is always going to be on the employee to prove that they were doing that. That they were discriminating based on pregnancy or sex. This is the overarching federal law. It applies in every state and I think territory. It is enforced by the EEOC, and if the EEOC doesn't take it, you can go to a private attorney and they can help you with it or help your clients with it. But again, it does have to have, your employer does have to have 15 or more employees, or I think be a federal agency or federal employer. To apply. So if you have work at a small company and there's only 10 employees, like they don't have to comply with this, which is kind of wild if you think about it, but that's the law. FMLA, Family Medical Leave Act, you are eligible, a person is eligible to take 12 weeks of unpaid leave if the employee has worked for at least 1 year of 1,250 hours, and the company that they work for has 50 employees in a 75-mile radius. So it's actually a number of boxes to check to make sure that a person is eligible for this. If they've maybe worked 1,250 hours, but they've only been working there for 10 months, they are not eligible for FMLA. If the company that they work for only has 40 employees within a 75-mile radius, so maybe they have, 3 different offices in Marietta and Atlanta proper, and maybe Decatur. I'm trying to get my Georgia geography together. But they only have 40 employees. Like they don't meet this FMLA standard, and they don't have to give you that. So, so it's interesting because most people in this country are employed by small employers. I've seen small employers defined as 20 or so. So a lot of people are not even eligible for this, but this is the federal law that exists. And again, like I said, it's unpaid, which, take that as you like, helpful or not. Lactation protections. Okay, so this is sometimes where you see maybe they didn't discriminate against somebody because they were pregnant, but now if they want to go pump, now they have a problem with it because you're taking up company time to pump. So under the Fair Labor Standards Act, they have to give reasonable break time for an employee to express milk. They have to. And there's a time limit for up to a year. And they have to give a place other than a bathroom that is shielded from view and free from intrusion by other people. So basically a room that will lock. Okay, that's what you need. This is the federal law. I know in California, this is a little bit different. There is no time limit. So this 1 year, I think, doesn't exist. It has to be, they also have to, at least in California, have a sink or a cooler and a fridge. So access to electricity while they are pumping. But that's the federal law. It's the base. But everybody doesn't do this, and a lot of people don't know what's required. So here's Maryland. So I pulled this. Who was in Maryland? I forgot who it was. I know Akila, I think, is in Maryland. Okay, and I included DC here just because the way the DMV works. I know a lot of people live in Maryland, but they work in DC. And so if there are people maybe who live in Virginia and work in DC, it's helpful to know. So Maryland says the pregnant person has a legal right to a reasonable accommodation, which is great. On two conditions. One, if the pregnancy or causes or contributes to a disability. So you actually have to be disabled by pregnancy. You can't just be pregnant, which is kind of unfortunate. And the accommodation does not impose an undue hardship on the employer. There's always a question, what is an undue hardship? And it really depends on what the nature of the employment is. I have seen this come up when people maybe are cashiers at Target, let's assume, and they just ask for a chair to sit while they're checking people out. It doesn't really change the nature of the employment. They usually provide that. It's not very difficult. They used to fight that and say, well, if you want a chair, then everybody else is going to have a chair and we're just providing chairs. So what? Like, what is great? Give everybody a chair that wants a chair. It's not that difficult. And it's not an undue hardship, especially on a place like Target, which clearly has the resources to provide everybody a chair if everybody asks for one. But if you're a small business, maybe you don't have the ability to provide, I don't know, a mechanized stair lift from one floor to another if you can't walk the stairs because of preeclampsia or something like that. So it's really up to the plaintiff or the worker to say, it's not an undue hardship on the employer. Here is the device I found that would help me. It's a walker, or it's a seat cushion. It costs $10, right? And they don't want to give it to me. That should be easy. The employer also has to explore all possible means of providing the reasonable accommodation. So they can't just say, oh, well, we looked at getting you a chair. The chair you want is too wide, so we're not going to give it to you. Well, they have to say, well, is there maybe another chair that could fit, right? And they can request a physician note if they would do the same for anybody that had a disability alone that was asking for the accommodation. And again, this is 15 employees and includes state workers. So if you work for the state of Maryland, or I think any other public agency within Maryland, like maybe the city of Baltimore or something like that. For DC, I skipped ahead, hold on. There we go. So for DC, their law is a little bit different. They require employers to protect all pregnant workers by giving them a reasonable accommodation if requested. And it's regardless of size. So you can employ one person and you're subject to this law. And that's nice, because why wouldn't you want to accommodate pregnant workers? It fosters healthy babies being born, which leads ultimately to healthy children, right? There's no reason to not request this. And so as I understand it, the District of Columbia law applies to also the federal government. And anybody basically operating within DC. So moving on to maybe less protective areas. So here we have Georgia. There's no specific law relating particularly to pregnancy. Georgia has a law called the Fair Employment Practices Act. As I understand it, it only applies to public employers. So that would be state agencies or city agencies or municipal agencies. And you have to have 15 employees for it to apply. And basically it's just no discrimination based on sex, and pregnancy falls under that, but there's no pregnancy accommodation that's required. Similar thing in Texas. The agency that enforces this law is called the Texas Commission on Human Rights. And the Texas Commission on Human Rights Act says there's no discrimination on the basis of sex, including pregnancy. And basically they're treated like disabilities. And you have to have 15 employees to be subject to that. There's very little kind of specifically on pregnancy accommodation or anything like that. My understanding of Texas is it's called a right to work state. It's not an at-will state like California. And so basically the burden is kind of on the employee to show why they weren't accommodated and how that's a violation, as opposed to on the employer to say we did accommodate this person. Similarly in Florida, on the Florida Civil Rights Act just says there's no discrimination on the basis of sex. There's nothing specific about pregnancy leave. And again, that's 15 employees. So all of these, the federal law still applies here. You have that basis, and the federal law is always going to be a floor on which the states can build and put more protections if they choose, but they don't have to. And a lot of times they just don't. There are a number of states that don't have any specific laws at all. regarding pregnancy. So at least these three have noted what's happening. So we talked a little bit about California. California has a number of different laws. The main thing, employers must provide an accommodation for a pregnant employee. They can request a note, but the accommodation doesn't require a note unless they request it. The specific one that's, I think, really wonderful about California is they have something called pregnancy disability leave. It applies basically as soon as you work at a place. If you get hired on Tuesday and on Wednesday you say, I'm pregnant and I need to take time off to go to the doctor, they have to give it to you. There is no waiting time. They have to return you to your same position if you leave out on pregnancy leave and come back. They have to provide the same position unless there was, we sold the company. Okay. There is a reorganization and everybody has changed. Okay. Those are different things that aren't specifically related to that person's pregnancy, but generally they have to put you in the same position. And we talked a little bit about the lactation accommodation. And you have to have a sink with running water and a refrigerator close to the workplace, or you can have a cooler. We have a lot of farm workers out here, so oftentimes they'll just provide a cooler. They can't really provide a sink and a fridge. What other thing? Oh yes, for pregnancy disability leave, it's 5 employees. Our Fair Employment and Housing Act is 5 employees for discrimination, and you only need 1 employee for harassment. So that's helpful to know. Sorry, I know I'm running through that kind of quickly. So one of the main issues is like, is there pregnancy discrimination? So sometimes when people come to me, they tell me about a situation, and by the time they've come to me, I'm like, oh yes, absolutely. Like, this is pregnancy discrimination. But it's helpful to think about a rubric before you decide, well, do I need a lawyer? Or, is this actually a bad thing? What's happening? Is it illegal? What's happening? So first, what's actually happening? Are your clients complaining that maybe their hours have been cut, or they're not scheduled for certain shifts, or they're scheduled for weird shifts? Things are being moved around. Is there evidence of this, so a shift change? So maybe somebody had day shift. I see this happen sometimes. They have one shift. They've always worked from 8 to 5 for 5 years. They work the 8 to 5 shift. They get pregnant. Boom. Next thing you know, oh, you're on a swing shift. You're on from 5 to 1 in the morning. Why? Oh, we just made that change. No reason. Okay, that's very strange, right? Sometimes employers do this if they know you especially have little kids at home. And so you relied on kind of that 8 to 5 to deal with your children coming home from school or whatever. And now you have to struggle to try to figure out, how am I going to get my kids covered if I have to be at work? You have to name what's happening. I'm always a big proponent of receipts. So I'm like, take pictures of the schedule if you have it, make a copy if you have it, keep it at home. Are other people who are not pregnant being treated the same as you or different? Because that's usually a big decision. So if everybody got moved to that second shift, or if they said, okay, we're shutting down this particular facility, that's not necessarily just targeted at the pregnant person, right? That might just be everybody. But I would keep a note, like, is it just you, or is it these other people? Or is it also other pregnant people? Sometimes you'll see this in an organization when that's large enough that pregnant people can actually get together and find each other and say, is this happening to you? This is happening to me too. Okay. And then are you sure that the treatment is happening because you're pregnant? So sometimes there will be comments that go along with stuff. Sometimes I've seen it in weird ways where a woman in her 60s will say, I don't want to work with any women in their 20s because they all get pregnant and they all leave. And everything I've taught them goes out the door, and I don't want to work with them at all, which is wild to me that people would say that, but some people really do feel like that. In that case, that would be a good comment saying, yeah, I'm pretty sure this treatment is because I'm in this class. And I just put an example. Is there a pattern of people maybe not returning after pregnancy? Does the company have a legitimate business reason for the treatment? So like I talked about, maybe if they shutter a whole facility, I mean, that's a legitimate business reason. It's not necessarily targeted at one particular person. The problem always comes up when they don't have a good reason. Or maybe they did a reduction in force and everybody that got termed is over 60, but they kept all the 30-year-olds. That one's always really interesting to me. It's like, can we not read? Like, I clearly see what you're doing. It's why just writing it down actually makes it worse. But, that's just something to look for if you're not sure whether it's pregnancy discrimination. And then how do we respond, right? So if you're hearing your clients, you're doing an intake with them, or you're checking in with them over the course of their pregnancy, and they keep repeating things that are happening at work, or how was work today? Oh, it's so stressful. You know, they gave me all these boxes to carry, and I usually don't even carry boxes, but they did today, and they have been for over the past few weeks. Like, let them name what's happening to them. Let them actually say, you know, you can have them explore that, like, oh, like how, you know, what is this upsetting to you and why? Have other people at work notice what's happening? Other people at home noticing what's happening? You're constantly complaining about work, how you feel. Are there any allies at work that you can talk to about the situation that's happening at work? That's always very important. It doesn't even have to be anybody in a position of power to do anything, but just somebody that you can, like a work friend. A lot of people joke about work wife or work husband, or just even a pal at work, or just somebody maybe in a different department who's not even seeing what you're seeing. Somebody you can talk to contemporaneously and say, hey, this is what's going on. Is this weird? Right? Because then that person, at the very least, could be a witness later, or at least can be another ear to just kind of assist with what's happening at the workplace. Because it can be a very isolating time if you feel like you're being discriminated against, based on pregnancy especially. How does your body feel when you're driving into work or you're riding into work, right? Are you tense? Are you eagerly looking forward to going to work? Or are you like, oh, not this again, right? Like, it's important to kind of notice how you feel about when you're going to work and when you're leaving. Are you interacting with somebody throughout the day of that work that makes your heart rate go up? Do you get sweaty when this person comes into your office? What are they going to say today, right? These are all things that your clients want to be mindful of what's happening. Sometimes in the moment, it's easy to like, oh, I hate this person or whatever, let it come and go. But if somebody writes it down and begins to see a pattern of this continual behavior that's happening, you can name it as, this person is actually harassing me, right? This person is creating an environment that is unhealthy for me and for my child. Find ways to resist the activity. This is the hardest one. And I know we're running a little bit short on time, and I kind of wanted to talk about different things that we could talk about to do. So my favorite one, as far as resisting the activity, usually this comes up in terms of harassment. But like if somebody comes up and says, oh, you know, did you send over the presentation to the clients for whatever? And you go, oh no, I'm going to send that right now. I got the email drafted, I haven't sent it. And they go, okay, well, I know you have a little baby brain, right? Seems like a harmless comment, something like that, right? And you go, just ask them, what do you mean? What does that mean? Force the person to articulate what they mean by the comment, right? So if they say, oh, you probably have a lot of baby brain, or they make a comment, I'm trying to think, like the example, well, your boobs are bigger. Well, what do you mean? My boobs are, oh, well, I look at everybody's boobs. So your boobs actually look bigger because you're, okay. Thanks. I mean, at least then you know, right? If you're forcing them to say, what is the basis of the statement? This happens a lot in sexual harassment. Have you ever heard the phrase, like, that's what she said, or something like that? If somebody says that and you go, what does that mean? That's what, like, if you just act like I don't really know what that means, explain it to me, then the person will be forced to say, oh, well, that's what she said. Like, and then once you explain it, you realize how rude of a comment it actually is. It's saying women are only objectified, and appropriate to say things when it's a sexual, right? Like if you force them to actually say what they're saying, it's helpful, because a lot of these comments and jokes rely on you, the person who's hearing it, internalizing what the meaning is without them having to say it. If you make them say it, instead of getting competition, like, what do you mean? Just, I don't understand the joke. What's funny? If you make them articulate what's funny about it, then either you have a better understanding of what they actually mean, too. They have a better understanding of what they actually mean. And hopefully they won't say that kind of thing again, because what they're really saying is, I'm demeaning you because you're pregnant, right? I'm saying you're dumb because you're pregnant. That's what the comment really means. There are other ways to kind of resist the activity, but that's my favorite kind of disruptive one, is like just asking the person, what do they mean? You can also oppose it, but that gets into more of a confrontation. And I don't know that everybody at work is ready to have a confrontation. And it may not be the best move work-wise, but this is something that, you know, we can talk about. And then the question is, can you escalate it higher, right? Do you have a human resources at your work? Are they helpful? Usually not. Usually I don't advise people that HR is helpful. Sometimes they can be though. And if you don't involve them, they can't help. Is there a manager or supervisor that could help? Does it help to go maybe above them to maybe the C-level? If there's a CEO or somebody, or the owner of the company or what have you, could they help? And it's possible that there's an accommodation that could be requested and provided. Sometimes they just separate the harasser and the person. And sometimes that's enough, right? Like sometimes getting you out of the environment or getting your clients out of the environment where that's happening, even if it's just for the time of the pregnancy, makes a world of difference. You have somewhere new to go basically, or they have somewhere new to go, and you're not having to, the client's not having to deal with this madness, right, at the time of their vulnerability. So that's helpful. And finally, oh no, what happened? Oh no. That was weird. Finally, validating the pregnant person's feelings about what they're going through is kind of the main thing that a supportive person can do. Obviously, as doulas, you're going to be contacting your people throughout their pregnancy, and just acknowledging what they're feeling and going through, I think is huge in terms of them feeling not isolated and alone. Sometimes people may decide to take action or not take action, and there's no right or wrong answer. We do a very good job of supporting people that are pregnant and supporting families and supporting people with young children. And so it may be the best move to just kind of survive in the workplace, depending on what your job is, how likely it is you're going to get another job very soon. And people have their reasons, right? And that's okay. But it helps, I think, to validate what people are going through. If they have a physician that they regularly see, maybe that's an OB or maybe a therapist or counselor. I even encourage people to talk to their ministers or imams or anybody that they regularly see at their house of worship, because those conversations are protected under priest-penitent privilege, and they can be therapeutic. And finally, just to write stuff down, like, even if it's just a note to themselves, it can be a note to you. Just, this is how I feel when something happens. I feel angry when they make jokes. I feel angry when they touch me, they don't ask permission. I feel bad when they switch my shift. I feel frustrated that I've talked to my supervisor and they're not helping. All of these things help validate the person as a whole human, not just a carrier of a baby and not just as a worker, but as a person with goals and ideas and thoughts and abilities. For me personally, it helps later when I see notes that have been documenting what's happening, but you know, I'm looking at this and not just the litigation, you know, the litigator who's like looking for evidence for court, but also just in terms of actually helping better our community and creating healthy outcomes for people. Because I always tell people, you know, the day I don't have a job because their people aren't coming to me because they're not being discriminated against is a great day. It hasn't happened yet. I'm hopeful that we can certainly strive to get to a place where people aren't being treated differently because of who they are. But we're not there yet. But at the very least, these are some steps that I think could be helpful in your practices with your clients, of recognizing at least, you know, if there's a situation, what to do about it. And so I'm very thankful to have been able to present to you. I appreciated the questions. I hope if you have any other questions, I don't know if we have any time for discussion, Akila, if you think, or if you want to just email me a question if you don't feel comfortable sharing with everybody. But thank you so much.
Yeah, we have this time. So as much time as you have to stay after to talk.
Yeah.
So if you guys want to ask any additional questions, the floor is yours.
I'll stop sharing. Hold Unless, well, I'll keep it just in case you want me to hop back to anything.
Are you only available to clients in California? Or like
I
can you-
only represent people in here, or employers that have been based in California, but they might have employees somewhere else. But all of my practice is California specific. But certainly if there's a question that you have, for instance, is it Harris County or something like that, I can find people. There's a set of attorneys that I know that does very good work in Harris County. There are people that I'm affiliated with or that I know in those places that I'm happy to refer to if you have questions specifically.
Okay. I'm gonna take a picture of your information just to have it.
Oh, okay, sure. You know what I can do also is I can send this slideshow to Akila at the end, and maybe she can send it if people want it.
Okay.
It's up to her. I
Yeah, we
I
can
have no
make it
problem.
available. So we were gonna make the recording available to everyone and for people who missed
Okay.
it. And so we can also provide the slideshow as well, so.
Is there a lot of cases of this happening in California or
Pregnancy discrimination? Absolutely.
mhm.
Absolutely. And it's funny, you see it come up in all different kind of industries and contexts. So it came up, the funniest, well, I won't say the funny, they're all kind of ridiculous. One of the ones that I thought was so interesting was a bartender. She wasn't a waitress. She wasn't, a sparkler girl behind the bar, a bartender. So she's behind the bar. You're not seeing her out. She's not walking around. And they fired her because she was pregnant. And the reason that they gave in the deposition that they fired her for, they said, well, we didn't want her to be lifting these heavy kegs and she could damage the baby. Literally, that's what they said. And she was like, I never lifted the kegs. Like, I'm 100 pounds basically. And, she's like, I'm 5 feet tall. Like I never lifted, like that was always some guy or whoever brought in the kegs always lifted. She's like, that was never my job responsibility in the first place. And at
Right.
deposition, it turned out the guy who fired, say it again.
I said that's what the bar back is for. Like the
Right.
bartender never touches stuff like that.
Right. And it turned out the guy who was running the bar said, well, his girlfriend was pregnant at the time and she had been complaining of all this stuff about how she felt. So he was imputing that to her and saying, well, if my girlfriend feels like this because she's pregnant, I don't want her to feel bad while she's pregnant. I don't want her back to hurt. So I'm just going to fire her. So I was like, so sir, you're saying you didn't want to cause her any physical discomfort, but do you understand when you fired her, you caused her like economic discomfort?
Right.
And he was like, yeah, but she has a husband. And but that's exactly the thing. It's like, it's not about her husband. Like it's about her. Like
Yeah.
her work has value. The reason that they gave didn't make any sense because that wasn't even her job responsibilities in the first place. And it came from this very paternalistic, like, oh, we're going to help you, right? Like you have a man. Like it was very strange. But that was, that it happens all the time. And that's just one, it happens all the time. A lot of times it'll happen where the person will go out on leave and then they, oh, we've changed your job while you've been
Right.
away. Now you're going to be doing this. It's always a return to work is a problem. So yeah, it just
Thank
runs the
you.
gamut. There are people, I've handled so many pregnancy cases. I don't want to go through a whole horror story of ridiculous pregnancy cases, but there are people who are actively hostile to pregnant people. I had a case where a pregnant woman was a dental tech and she told it was a small, dental office. So she told the boss, like the head dentist, like, oh, I'm pregnant. And he was like, oh, all right. Well, it's not really helpful to me that you're pregnant and you should really think about getting a new job. And she was like, I wasn't planning on doing that. And he goes, okay, well, you can start administering the nitrous oxide then. She was like, that wasn't ever my responsibility. He's like, it is now. And he made her sit in the room with the nitrous oxide being dispensed to patients. Yes. Yeah. So like he acted, and this is dental school, like medical training. Like he went out of his way to actively expose her to nitrous oxide. Make it make sense. I mean, like he could have literally just done nothing.
That's terrible.
It is. So it does still happen. It does still happen. I think people feel very possessive of pregnant people in their bodies. And so the touching and the comments, because it's like community pregnancy, right? It's like everybody wants to say something and feel like they have, you know, how many, I didn't ask your opinion, but here you are telling me about how I look, right? Like it's
Right.
kind of like one of the last few cases people feel like they can say stuff. So
But I
it's
think
very interesting.
some of the people are afraid of saying too much, thinking they will get fired, or if they don't get fired, the treatment that they will receive, just, you know, even contacting you would be not so pleasant. So what do you kind of say in that case where they come to you and they're like, you know, listen, I'm getting these particular treatment. However, I need my job. I'm a single parent. I don't have any other kid, but I don't want to be constantly being treated like this. Is that still a case, or?
Yeah. So I would say by the time people come to me, I would say 85% of the time they know that they're done. By the time it gets to where they actually have either called or we have a meeting or they're in my office and I'm looking at them, I'm like, so why are you here? And they'll go through the whole thing. I'm like, okay, but really, why are you here? Like, and I never tell them but I'm like, you know why you're here. This is, you can't take this anymore, basically. Like that, if you come to the step to where you've actually talked to a lawyer, the situation is untenable. And usually the person has gone through a number of efforts to try to resolve it on their own and are not having success.
Okay.
And what it comes down to is the workplace is not giving them the support that they need. Now, whether what they need or want is attainable or reasonable is a whole different question.
Right.
And that's an individual case-by-case basis. Sometimes we come up with strategies on, okay, this is our timeline. You know, you've worked there for X amount of time. You're going to take your leave. You know, it's horrible. But if you know it's horrible and you know you're not coming back, then we can work with that, right? Or if you know it's horrible and you expect them to continue doing shenanigans, you're going to go into HR tomorrow and tell them what's happening. And then if they do something, then it's retaliation, right? So there are kind of like ways and strategies that we can talk about what's happening. But ultimately, by the time, if they've come to see me, they know they can't, there's no long-term future there,
Okay.
usually.
Wait, I got
Even if
one
they're
more
still
question.
working there, like it just, they can't stay there.
Okay, I got
So,
one more question. So
yeah.
with these type of cases, is the ultimate end game is payment, is what's the ultimate end game?
It depends on the situation and what type of workplace the person is in. So
Okay.
it happens sometimes where maybe, like I'm in California, there's a lot of tech startups. A person has been a founder, right? A person has like been there since employee number 2 or whatever, and they feel like they have equity in the company and, you know, they want to stay there. It's very difficult. It's happened, very difficult to sue somebody and stay there. So we need to decide, do you want to stay there? What is it worth to you to stay there? Okay. You think these stock things are going to mature. You think you're going to get an IPO and okay, then it makes sense for you to stay there. Most people are not in that situation. That's a very rare situation. Most people are in a situation where they're like, I'm ready to leave. They need to pay me. Right. They can't put the genie back in the bottle. Like it's unless they fire the harasser and say, oh, we're so sorry. We didn't know this is what was happening. That I don't see that in the pregnancy context, because by the time they've come to me, everybody knows that they're pregnant. So the employer already knew, right? I see it happen sometimes in the sexual harassment where maybe everybody didn't know the person was being groped or sexually harassed or whatever. But in the pregnancy context, everybody already knows the person was pregnant. And so generally the company is on board with signing off on whatever the manager has done to minimize that person's advancement. to not give that person the bonus, to not give those person the hours.
Okay.
One of my favorite ones is when they schedule the pregnant person for 0 hours for like 3 weeks. And so they're like, this is fired, right? They basically fired me. So I call and they're like, well, we didn't fire them. We just scheduled them for 0 hours. And I was like, so they're not getting paid and they're treating it as you're fired. So you're not firing them? When are you planning to schedule them for more hours? Oh, we don't have any plan. I said, okay, so they're constructively terminated. Thank you. And that was it. And so we filed a lawsuit because this is the kind of stuff that they do. Just so they could, oh, we didn't fire you. We just creatively scheduled you for nothing. I mean, that doesn't make any sense, right?
Right.
So it really just depends. But ultimately, you can never put that Humpty Dumpty back because the environment is ruined, like because they allowed this to happen. Like I said, by the time they're coming to me, they've already talked to somebody. They've talked to a supervisor, a manager, they talked to HR. The situation hasn't improved. So basically, the relationship is ruptured. And unless it's a rare situation where somehow the people in the control of the company didn't know, the only thing to do from them is to maximize the amount of money they get paid when they leave, period. Because that's all they understand is money, these companies. Sometimes you can try to get them to, I won't do it again. Very rare. And usually if you do that, you have to have sued them in the first place.
Thank you.
You're welcome.
You have a question in the chat.
Oh, let me stop sharing then. Hold on. Chat. Oh, there's a whole bunch of stuff in the chat. Okay, let me see. Yeah, making you resign. Yeah. Yeah, I mean, without knowing specifically, if they make you resign, that is a termination. So in California, you would have the pregnancy disability leave in addition to the FMLA CFRA, basically. It's pregnancy disability leave. So you get 8 weeks of that, 2 weeks of basically maternity leave, and then 6 weeks of baby bonding. And then on top of that, you get California Rights Act, which is another 12 weeks unpaid. So ultimately you can get 17 and a half weeks. On top of that, you can say, I have a disability, which is postpartum. My doctor is recommending I have X amount of leave, return to work or whatever. They have to work with you. They have to engage in what's called the interactive process. Now, they're going to say that's not necessarily a disability relating to pregnancy, but that's fine. It's a different disability. You could say it's unrelated or not. It doesn't matter. If it's anxiety, that is a separate and different disability. It's not related to pregnancy. They have to have a reasonable accommodation discussion. So if this is this Texas? Where is this? I don't know where this is.
Taylor, are you
Depending
still
on
in the chat? I think you asked the question.
I would
I think she's
ask,
gone.
I think she's gone.
is she? Okay. Well, depending on where she is, I would say so even if the only law that applies is the ADA, which is the federal law, the company has an obligation to engage in the interactive process and they have to have a discussion. They can't just say you're terminated. Once the person has given notice to say, I have a disability, which is anxiety, or I have a disability that requires reasonable accommodation. Can we set up a meeting and talk about it? Okay. And then it's basically starts a whole different ball rolling. So that's what I would recommend for them to do. Okay. Well, it's been great. I actually have to jet. If there is any question that I didn't answer, please feel free to email me. Let me share my screen again so people can just see my email. Just let me know. Happy to answer any questions, or I know somebody had a question about Houston attorneys. I'll put you in contact with those people. But it's been wonderful. Thank you so much, Shakila. Thank you for having me.
Yes, thank you. This was really, it was a great presentation, and thank you for sharing this information. And we'll make sure that everyone has an opportunity who wasn't here to view it, and we'll share the presentation with everyone. So
Yeah,
thank
it was
you so
great.
much.
I didn't even know that it existed. Like, I figure you're pregnant, you're just out of luck. These things happen. And especially Georgia, I call it a free to fire state because for any reason they let you go and they say they don't have to give any rhyme or reason. And people don't even realize that they even have this right. because that's the way they set it up in your head to think. So, I mean, yeah, this was definitely informative.
Good, I'm glad. And don't forget the federal law, even if there's no particular state law, the federal law still applies. So it's still illegal to fire people just because they're pregnant under the Title VII. So that's still a floor applicable to every state. I don't care what Georgia specifically is saying by itself. So,
Okay. Awesome.
well, thank you so much.
Thank you.
Yes, thank you so much.
Hey,
Everyone have a good
Tracy.
afternoon.
Okay, you too. Bye-bye.
Bye-bye.
Bye-bye.